I think you call Blair, I think what you call, Blair, an unprecedented moment, and it really is that. Significant changes over the last 6 months in the US, cuts to federal funding, foreign aid programs, and similarly in the UK, sort of significant disruption to FCDO funding, cuts in budgets, other funding challenges, funding pressures in the UK caused by increases in employment taxes, and other taxation issues for charities, compounded by an increase in the need by beneficiaries, and obviously sort of cost of living, energy type challenges as well. All of this has created profound and significant financial difficulties, and unfortunately, in some cases, potential insolvency type situations. And as Blair mentioned, and I think, Blair, hopefully everybody's had access to the excellent guide that you produce with Digital Public and Development Gateway, the Civil Society Strategic Partnership Toolkit. But it really is an excellent guide to setting out the sort of key steps that you as organisations will need to look at when considering how to deal with potential future challenges. And I think one thing just to sort of pause and say right at the outset of this presentation is that even when the answer is closure, there is a significant difference between a good and a bad ending. And if you manage the ending well, and preserve something of the legacy that your charity has been able to deliver over the course of your lifetime, then both your staff, supporters, funders, and beneficiaries walk away from the project feeling like you have made a difference, and you have made a significant impact on your wider communities. If it's all a rush to the end and you don't get to do these things properly, then it can have a traumatic impact. I don't think it's over-egging the pudding to say that. So what Luke and I are going to do this afternoon is to talk you through both potential merger process from a legal perspective, and then to have a look at wind down. So Luke, over to you. Thank you.
Thank you, Jo, and thank you to Blair, Sara, and Glory for your introductions and for coordinating this session. It's good to be with you. Next slide, please. So we thought it would make sense to start off looking at the different structures that mergers can take, just to give us a sense of how these things can happen, how they can unfold, what the end goal might look like. You'll see a very prominent credit here to the Good Merger Index, which is published by East Side People. So East Side People are leading third sector consultants. They advise on mergers. They do merger due diligence, merger research, and they produce the Good Merger Index each year. The last index was 2023 to 2024. So they analyze the information in the returns to the Charity Commission and use that to analyze how many mergers have taken place. And in that year, there was an increase of some 30%. So the trend is upwards. And there were about 60 mergers in England and Wales, with about 130 organisations involved. Now, this taxonomy of the different types of merger structures is East Side's. It's not a legal taxonomy, and that might become obvious as we start to analyse it and talk about it, but it's a helpful way of thinking and a helpful division. So if we look at the first column, this is a merger where we're really talking about, to some extent, the coming together of two organisations as equals to create something new. And that could be in the form of a new legal entity, or it could be simply in the form of an entity that's rebranded, that has a new identity, that is structured in a new way, operationally has a new top team, for example. So that you might describe as a merger. Actually, that's relatively rare, it seems, in the data. Most mergers are not coming together of equals. They're more in the second column. They're more takeovers. This is by far and away the most common type of merger that we see. And typically, this will involve an asset transfer. So the transfer of assets from one organization to another. and one organization gets subsumed by the other. So here we see B is effectively subsumed into A. And in this context, typically A will retain its brand, its identity, and its legal form, and the assets of B and the undertaking of B will perhaps become a program within A. We also sometimes see the third column, the subsidiary model. So in this model, we have B becoming a wholly owned subsidiary of A. This can be a really useful preliminary step to a full merger. It can be a way of ring fencing risk within B and avoiding the risks that would go with a full asset transfer. And so it can be tempting to do this sort of structure if time is of the essence, if there are real pressures, if there's not enough time to do due diligence, and A wants to make sure that if there are liabilities in B, they don't threaten the viability of A. At the same time, there are reputational risks for A in taking on B in this sort of structure. So even though legally B might remain a separate entity and legal liability might remain within B, if B were to fail, that would reflect badly upon A, and that normally focuses minds. And so typically, even in this sort of structure, A will want to do due diligence and to understand what it's taking on. It may be that perhaps it can't get to the bottom of the due diligence, and that might influence why that sort of structure is taken on. Sometimes it's a deliberate structure with the understanding that A and B need to remain to some extent administratively separate, and there's a logic to it. Sometimes, but much more rarely, we see column 4, which is a structure where sometimes you have charities, in this case A, that deliberately maintain a group structure. So they deliberately have a number of charities underneath the umbrella, provide shared services, and that can be a deliberate strategy. It can be a strategy to acquire allied complementary charities. And there aren't many examples out there, but there are some charities that do this in a very deliberate way. And then we have column 5, swapping services or assets. I think the easiest way to think about this is divestment. So divestment of a program would be a typical example. So you might have charity B that develops a program, but realizes actually, on reflection, A is better placed to be a long-term home for that program, and B chooses to divest the program to A. In that sort of situation, typically that also involves a transfer of assets, and legally, often it looks quite similar to 2. Often the challenge there is to discern what the intellectual property and the assets are in the relevant program, and to distinguish those from the assets that are remaining in B. So that's a quick canter through some of the different structures that we see, and there can be a logic for going in different directions. Hopefully that gives you a frame of reference for what follows. So I'll hand back to Jo at this point.
Thanks, Luke. So Sheena, if we just go to the next slide, thank you. I suppose it goes without saying really that the first step is finding your partner, which perhaps is easier said than done. But there's some really good questions to help you with a landscape analysis, which is set out in the Strategic Partnership Toolkit that was produced by partners on the call today. And that will give you some ideas about how to start and where to look. There are also now increasingly a number of organisations that are happy to act as merger brokers or partners, or you can have confidential discussions with to see who may be in the market for sort of potential discussions or mergers. I would say that probably 60 or 70% of the mergers that we work on are with partners who have known each other before. So they have worked together, they have developed a trusted relationship over many years, and are now looking to work together more strategically and in a more coherent way. And often it's those potential merger discussions where there are trusted relationships over a number of years that are more successful. Because I'm sure Luke will agree, but unfortunately we see many mergers that don't really get off the starting blocks and get out of that first stage. So you found your partner. You may even have had 2 or 3 potential partners that you want to talk to, and then need to have some early doors discussions. It's really important at this stage to be clear about who your circle of confidence is, who is going to be involved in the discussions, both from your side, and then to make clear who in potential merger partner this can be shared with and discussed with. And normally these very preliminary discussions will take place, not even with the whole board, but generally between the chairs and perhaps vice chairs, and maybe the chief executives of the charities as well. And once there's an early indication that it's a discussion that the potential merger partner may want to have, then need to look at agreeing some form of confidentiality agreement, an NDA or broader form of confidentiality before you start to bring people into the loop and start to share information. It's really important, particularly in these difficult times, that these discussions remain as confidential as they can for as long as they can. As I said a few moments ago, many of these discussions don't get very far, and even fewer of them actually get to completion. And so it's important that these early discussions are dealt with carefully and that confidentiality is preserved. And one of the reasons for that is because if your partners or people within your community of organisations become aware that you're facing difficulty or are struggling or may not be able to move forward, then very quickly things can start to unravel. So you can lose potential bids that you've got in, funding agreements may fall away. You may find that funders get in touch and want to start undertaking further risk assessments, looking at further funding that may be coming to you. So it's important that those discussions are kept within a small circle of individuals and that those confidentiality agreements are put in place. So once you're clear that you can have a discussion in a safe space, you then need to decide how the due diligence process is going to be undertaken. And one of the most important things, particularly from the charities perspective in England and Wales, is to have a look at compatibility of purposes. Quite often you'll find that you have two charities who are doing similar things, but they have very different charitable purposes. And when you're looking at the legalities of charitable mergers, then the ability to be able to move assets from one organisation to another depends upon how closely aligned those charitable purposes are. And if they're not closely aligned, then it may be that part of the assets will need to be moved across either on a restricted basis, or indeed you would need to look to talk to the Charity Commission about amending your purposes before the merger proceeds in order that the assets can move across in a free manner. We would generally suggest that due diligence be done in 2 phases, a kind of high level due diligence at the outset, looking at key financials, key employee information, and other important material and significant concerns to your organisation, which will obviously differ depending on what you do and how you do it. And then a second, more full due diligence process, which gets into some of the detail that we'll come on to look at in a few slides' time. As Luke said, the parties will then need to meet to talk about the structure. And it may be that the initial due diligence has made it completely clear that one or other of these structures is the only way that can go forward. So, for example, if one of the parties were to have a defined benefit pension scheme that would make it difficult to transfer across the assets of that particular charity to the other, then you might want to pass the assets in the other direction. Or if one has a significant leasehold liability, which you've got a difficult landlord and it would be difficult to assign the leases, that might suggest that B moves to A rather than the other way around. So sometimes the structure designs itself just by virtue of the assets, liabilities, undertakings and activities of your organisation. But if not, then you'll need to sit down with your lawyers at an early stage to look at what the best way of structuring the merger is. And the way in which you structure the merger will also significantly impact upon the steps that need to be taken and the timetable. And Luke will come on to talk about the merger agreement in a moment. But for example, if you are moving with the subsidiary model, then you may not need to undertake 2P consultations, which are legal employment consultations that have to be taken where there's a transfer of an undertaking in the UK. However, if it's just the subsidiary and the membership, or effectively the ownership of one charity is passing to the other, there may not be any transfer of employees, and therefore you may not need to undertake 2P consultations. So it's a little bit chicken and egg, and everything needs to be done pretty quickly in these types of circumstances, but you will need to decide or hit upon the structure at a pretty early stage of your discussions, because that will drive the process. The next key factor is timing. And I was interested to hear from Blair that most of the respondents to your surveys are suggesting that they only have 6-month runways. So timing is going to be incredibly tight, and these things are going to need to move at pace and at speed. My best advice, I suppose, would be to, once you've decided on the structure, make sure that you have a very clear step plan and timetable, with input from your lawyers, your accountants, your communications team, employee engagement, HR teams, etc. To ensure that everybody knows what needs to happen when and in what order, as soon as that can come together in a sensible fashion. And then, of course, and it's not on this slide, although it should be, the last stage in this process is going to be the approval by both of your boards. And in order for each of the boards to be sure that merger is something that they want to do, they're going to have to be able to take the decision that the merger is in the best interests of their charity, not in the best interests of both charities together or in the interests of charity more generally, but in the best interests of their charity. And so what's going to be very important for each of the boards to be able to see is a really clear business plan which sets out the rationale for this merger incredibly clearly, and articulates appropriately how this merger is going to further the charitable purposes of each of the charities. And it will also need to demonstrate to the trustees how the two charities will be stronger together, or if not necessarily stronger together, how the additional new activities that will be added will be helpful to the delivery of that charity's operations going forward. And then I suppose the next piece that the Board of Trustees is going to want to see, as well as the business plan, is the integration plan. And normally the integration plan would follow a little bit later in this process, but here everything is so compounded, there is so little time, that I think if this is going to be done properly with best possible chance of being successful, that integration planning, or at least the skeleton of what the integration plan is going to look like, will need to be developed at a pretty early stage and reviewed by the board. And that's integration of mission, culture, activities, HR, down to the sort of technical operational things like finance systems, IT, websites, etc. So that's all I wanted to say about stages. And Luke, I think you're going to look at agreements.
Yes. Next slide, please. So there are two different types of legal agreements that you might see in merger contexts typically. So one is an asset transfer agreement. The other is a parent subsidiary agreement or a grouping agreement. And I'll talk a little bit about the two of those. The particular legal forms of the two charities might influence the form that those agreements take, as well as what Jo was describing in terms of the business plan and the integration plan. Because typically what happens in a merger context is the two parties talk to each other, they take time, they get comfortable, representations are made about what the future will look like, and on the basis of those representations, they start to draw up plans to merge. And there's something of an art, I suppose, in capturing the business plan and the integration plan and any other commitments that are made that really are the basis upon which the two parties are coming together. And ideally, you capture those in the form of the agreement. So looking at the asset transfer type of agreement, this, as you would expect, lists the assets that are transferring. And sometimes clients will say, we don't have very much by way of assets, or we don't have any assets. Sometimes you'll hear that. And actually, with a little bit of due diligence, it becomes clear that there are assets. There's a website, there's a domain name, there's a database, there's goodwill, there's copyright, there are materials that have been created, and typically there's hopefully some cash. And there might be other assets in terms of real estate or contracts or funding agreements. And so ideally, the merger agreement lists all of these different categories of assets, so it's clear what's transferring. Typically, it will work on a non-exhaustive basis. So if there are other assets, they will transfer as well. Typically, the asset transfer agreement will also list staff and specify which members of staff are transferring with the assets too. Obviously, there'll need to be a date specified as the transfer date. Typically, there are conditions precedent to that transfer, which might include authorizations or third-party consents or funder consents, or particular things that need to be resolved before the parties are ready. And the receiving party, the party that's receiving the assets, wants to know that it's getting a, let's say, net asset. It's getting something worthwhile. It's getting a gift that's worth receiving. And for that reason, representations are made by the transferring charity about the nature of the assets that are being transferred. And these representations are typically in good faith, to the best of the knowledge of the charity and its trustees. They are also potentially the basis of a claim if those representations are misrepresentations. And so typically they focus the parties' minds on what has been disclosed about the nature of the assets that are transferring, and that all relevant liabilities and other matters have been properly disclosed. There can be a bit of a dance around representations. Lawyers can negotiate representations. It's typically one of the areas that lawyers will focus on if you're advised. So don't be surprised if you get that far, if people spend a bit of time thinking about this part of the agreement and getting their head around it, because typically there are also certain liabilities which are excluded. So for instance, if there is any deliberate misrepresentation, typically that will be excluded. The different law firms can have slightly different approaches and drafting conventions. So be warned that hopefully you can settle these issues reasonably quickly, but it might require a bit of thought. Typically, the transfer agreement will also have an indemnity provided to the transferring charity and its trustees, because essentially from that charity's perspective, it's giving away its assets, and it wants to know, and the trustees in particular want to know, that the charity is not going to be in a worse position as a result of making this gift. And so very often that indemnity will be limited to the value of the assets or an estimate of the value of the assets. Though again, this can be an area for negotiation, particularly if there are known liabilities and there are sensitivities, or there's some difference about what the value of the assets are. But again, that can be an area where lawyers can negotiate, and it can come into focus. There will then typically be some assets that require some further work to transfer. Hopefully, key funding agreements and contracts you'll have resolved, you'll have signed or novated as appropriate. But typically, there'll be some agreements that you won't be able to resolve ahead of a transfer date. So think of suppliers, for instance. And in that sort of situation, the transferring charity typically will say that it will do whatever is necessary to execute any agreements and to ensure that those assets are transferred. And that if they fail to transfer, then the benefit of those agreements will be held for the benefit of the receiving charity. Then there are typically certain clauses where we would get specialist colleagues to have a look. So data privacy would be an example of an area where very often some specialist advice is needed, particularly if you're talking about multiple jurisdictions or you're talking about sensitive data, and you get into what sort of notifications are made and at what point to recipients, and do they have the option to consent to their data being transferred or being processed by the recipient. Employment law is typically an area where there's specialist advice around consultation. There might be more tricky issues if there are particular liabilities or any restructuring is anticipated in terms of whether that happens, how that happens, whether that happens before the merger or it happens after the merger, and the proximity to the merger. Real estate, if there are leases involved, there might be the need for specialist advice there. I'd add tax to that as well. I won't go on about these because I think Jo's talking a bit more about some of the issues that come up shortly. Typically, there's some provision for what happens to the transferring charity after the merger. You will probably want to add the merger to the register of mergers, but there might be reasons why it might be logical to retain the transferring charity for some time. If, for example, you've got a bank account with direct debits and you want to retain that bank account for some time, or other reasons potentially. And then in the parent subsidiary context, if we are acting for the entity that's becoming the subsidiary, we might suggest some form of grouping agreement or affiliation agreement. So in this situation, often what can happen is the charity that's becoming the subsidiary decides to become the subsidiary on the basis of what the parent says about investment that it will make in the subsidiary or support that it will make in the subsidiary or how it will continue the programs for a certain amount of time. And you might want to see if it's possible to record those commitments, hold the parent to account to those commitments. And sometimes there's some brand issues that come into this sort of negotiation. And potentially, though rarely, there may be scope to unwind the merger. So in some situations, it's possible to say, look, we'll become a subsidiary, and if you do everything that you say you'll do, the assets might transfer up at some point. But if you breach your agreement, we get to reorganize and become independent again. Easier said than done, because normally the subsidiary doesn't have that level of negotiating power, but just worth noting. And I'll hand back to Jo to talk more about legal issues.
I have, over the years, provided a number of golden tickets for subsidiaries to be able to sort of go off and become independent organizations once again. I don't think I've ever seen a golden ticket type exit arrangement actually exercised. So, I mean, maybe
nice in theory.
Maybe they were just very successful mergers. Sheena, can we take 2 slides on, please? Thank you. So just looking at some of the key legal issues that come up. Normally, and in most mergers, certainly that we deal with, there will be a number of consents that have to be obtained before the merger can go ahead. So that might be external consents from third-party regulators who regulate the type of activity that the charity is undertaking. So, for example, if it was registered with an education body like Ofsted or otherwise, there may be regulatory consents that are required. But more often than not, the consents that you're looking for will be consents from your key funders, who will generally, in their key funding contracts, have a clause that says this contract cannot be assigned or novated to any other entity without our consent. And if you're contemplating a merger, or if there is a merger or restructuring or potential wind down, you have to come and talk to us at the earliest possible opportunity. So normally this point, because it requires third party consents, is one that needs to be high up on the list for discussion between the parties. And generally, the parties will agree which of them is best placed to be able to make that first approach to the funder to see whether or not the funder is supportive of the proposed merger and is happy for the funding agreement to be novated or assigned as may be appropriate. You also need to think about authorities that might be required. Not all boards of trustees actually have the power to implement a merger. In some cases, where a merger is contemplated, that will be something which is a power reserved to the membership of the charity. And it may be that you have to call some form of general meeting of your wider membership to ensure that proper consents are obtained at the right time. It may also be the case that you require authority from the Charity Commission. Now, generally, charity mergers do not require any form of approval from the Charity Commission just because they are charity mergers. But from time to time, and probably I would say 50% of the cases, we end up in front of the Charity Commission anyway, because there are specific issues with which we need their help. And normally that relates to permanently endowed funds or expendably endowed funds, where it's not possible to transfer those funds across without some form of order or scheme from the Charity Commission to enable certain funds to be moved between entities. It's also possible in certain cases where there's significant amounts of property, particularly where you've got an organisation with a number of leaseholds properties, to be able to approach the Charity Commission for consent to transfer the leases without having to seek landlord's consent. We've done that on a number of occasions, which has been effective in saving quite some significant sums for the charity. The third issue on the list here is pensions, which I mentioned in passing a few moments ago. But really, if you can see from your potential merger partners' accounts that they have a defined benefit pension scheme, or they have at any time participated in any form of defined benefit pension scheme, then generally you need to bring in a pension specialist at the earliest opportunity to have a look at what the potential liabilities might be and how you will go about transferring any form of liability across. And generally, where you're dealing with a defined benefit scheme, you will require separate pension documentation in order to put that into effect. And pension trustees, unfortunately, are not known for moving super quickly. So the sooner you can work out what's needed and get that lined up and onto your timetable, the better. If you've just got a straightforward money purchase scheme or sort of defined contribution scheme, then generally it's a lot easier to deal with. Data privacy is also something that will need to be looked at early doors. Most charities these days are pretty good ensuring compliance with data protection laws and ensuring that their databases of funders, contacts, beneficiaries, etc., are properly compliant. But that's not always the case. And where you've got one organisation which is data rich and data heavy and depends upon that data to deliver its activities, you're going to need to be able to undertake a data audit early doors to make sure that that's something that you are going to be able to either fix or manage the risk going forward as you move to bring the two organisations together. Fifth one on the list here is real estate or property. So if the organisation either has leases or freehold property in England and Wales, then you'll need to work out how that's going to transfer across. And if it's leasehold, almost certainly you'll need consents from the landlords, and you'll need to discuss when and if you're going to approach the landlords. Some charities choose to do that early if they've got decent landlords that they've built close and good working relationships with. Others decide not to tell their landlord and to deal with it after the event and deal with the fallout, should there be any. Staff is probably one of the most difficult issues, I would say, in a charity merger, and not necessarily from a legal perspective, but from a time perspective and from an emotional perspective. Staff working with your organisation, for the most part, will be invested in the organisation, passionate about the organisation, and most people don't deal with change particularly well. So this is going to be a very difficult time for the staff. There are also a number of legal processes that you may have to go through. So, for example, if there are any staff that will be lost as part of this process through some form of redundancy exercise, either before or after, or consultations that may be required in relation to the transfer of undertakings and 2P. This is all something that will need to be planned so that the proper representatives can be appointed if it's a collective consultation that needs to be undertaken, and everybody is clear, and the messages that are being communicated are as reassuring as they possibly could be in what almost certainly will be an incredibly unsettling time. So at a time when you're asking staff to work harder to make a merger happen and make something new and better, quite often they'll also be faced with uncertainty in relation to their own role. And that can be really challenging for the management to be able to guide their way through. And it can be quite a sort of lonely role at this particular point for the senior leadership team until you get back out the other side and everybody's sure about who will be remaining on staff and which members of the team will be taking forward different projects. We've talked about funding agreements and contracts. It's completely critical that you are on top of and managing these core agreements, not just the funding agreements that are coming in, whether it's from grant-making organisations and other sort of governmental funders, but also the contracts that you have with your partners working in the field. And you need to be very clear about the ability either to novate or assign those contracts, and also in what circumstances there can be clawback on those funding agreements. So most funding agreements are drafted in favour, unsurprisingly, of the funder. And generally there are very wide provisions which allow them to claw back in circumstances where there is any kind of reorganisation or merger or transfer or closure of the business, etc. And so it's really important that you have identified very clearly which agreements are going to be affected by those types of provision, and how much is involved, and then what the plan is going to be to talk to those funders, and in what order. Because as I said before, you need to be through enough of the process to know this is going to happen in order to take the risk to potentially disrupt the relationship with the funder. And again, it's another chicken and egg that presents itself. What is the right point to go to funders for their consents, and in what order should that be done? And for some charities, they decide to take a risk-based approach. They'll approach and talk to at length their key 3 or 4 funders, and everybody else they hope they can deal with in the sort of wash-up exercise with sort of a more global form of communication. And then finally on this list, it's not really a legal issue, except to say that generally, unless ISLP are able to step in and provide you with pro bono legal support, there is a cost to this which needs to be borne in mind. It's not just a financial cost of legal advice and accountancy support that you might need, but also do plan for the internal management costs. These types of processes are incredibly labour intensive. And in many cases where we're dealing with charity mergers, the role of the business as usual needs to be backfilled, because so much of the senior leadership time is taken up with planning for integration and merger. But they are incredibly distractive processes. Should we move on, Luke? I think we're coming on to talk about the other road.
Great. So Jo's going to talk in a bit about solvent and insolvent winding up, but I'm going to say a bit before that about monitoring potential insolvency in the twilight period beforehand, when you're in that grey zone and it's not entirely clear how things are going to go. So under the Insolvency Act, trustees have potential personal liability if they continue to trade and they knew or ought to have known that there was no reasonable prospect of solvency. So if a charity continues to trade, it goes insolvent. As a result, creditors lose money. They could, in theory, claim or seek to claim against the charity, and the charity could claim against the trustees. Now, it really gets to that, but the existence of that potential liability focuses minds quite considerably in these sorts of situations. And so responsible trustees naturally want to know that they are doing the right thing and that they're staying on the right side of the law. And sometimes this can be really difficult and can involve very difficult judgments with uncertain information in fast-moving contexts. There's also a criminal offence of fraudulent trading, which I'm sure won't apply in any of your contexts, but it's just worth knowing that if directors deliberately trade into insolvency and creditors lose out, there is that criminal offence in the background, which again focuses minds somewhat. Trustees also very often are professionals, have reputations, and just don't want to be criticised for getting it wrong or taking too long to take preventative steps. And so that often is also animating some of the dynamics in these situations. So the key question is there a reasonable prospect of solvency? And I'll let Jo say a bit more about this shortly. There's an income aspect to this. There's an asset test aspect to it. But where charities are navigating changes and the future is uncertain, and it's uncertain that they will continue to be able to meet their liabilities, trustees need to be meeting frequently. They need to be minuting their decision-making to demonstrate their reason for continuing to operate and to show that they are considering creditors' interests and avoiding losses to creditors where there's this risk of insolvency arising. And these situations can be fast moving, and so it's important to show that the board is responding to events, it's alive and aware of events. That might mean meeting more regularly than normal. It might mean meeting quickly if things change. There ought to be cash flow analyses, forecasts and regular reforecasting to show that that trustees are being prudent and doing what would be reasonably expected of them. And in particular, there's a need to monitor negotiations and bids with funders, because very often in these sorts of situations, there's some hope or expectation that a funder might come good and provide the funds to enable a charity to continue. If there are these sorts of discussions underway, it's important to respond quickly to intelligence. It may be worth informing the funder, depending on the relationship, about decisions that you might have to make if the funder doesn't respond as you expect, because sometimes funders might not want you to cut certain posts or restructure programs, and they might want to be informed about how your strategy is developing in this sort of context. Of course, you might need to make redundancies. You might need to take specialist advice on that. We have various clients that have scaled back or scaled down their operations, sometimes to skeleton operations for a period until they've seen which way the wind is blowing in certain contexts. That can be an option. You might need to take legal advice if the situation is particularly difficult, particularly rocky, to protect the trustees. And of course, you might need to take insolvency advice if it's looking like it's going to go in a certain direction, or you have particularly complicated assets or liabilities. So I'm going to hand back to Jo to tell us a bit more about solvent and insolvent winding up.
Thank you. Thanks, Luke. If we could just move on. I suppose one thing that I would say, having acted for many boards over the years that are sort of facing insolvency type situations, is that there is significant professional advice that can be provided by insolvency practitioners. And insolvency practitioners are not just the people who come in at the end to mop up the mess. If you are able to get hold of decent, good insolvency practitioners who work regularly with charities, they are incredibly deft at being able to turn around charities, to put things on a better footing, to make suggestions that may not have occurred to you. And the other really important thing about bringing in an insolvency practitioner at an early stage is that it provides a significant degree of reassurance to the trustees that they're taking the right steps, that they've considered everything that they need to take into account in these difficult situations, and that if they do decide to trade through, and they are waiting for funding to come in, and 90% certainty of a certain funding stream coming in 3 months' time, that was a reasonable decision for them to have made, and they're not going to find themselves subject to criticism later in the day. So when you're deciding that you want to close down the charity, you need to be really clear about whether or not you're solvent or insolvent. And sometimes that's just not the case. You just don't yet know whether you're going to be able to implement a solvent wind down. The test is twofold, as Luke mentioned. Do you have sufficient assets to meet your liabilities as they fall due? And secondly, do your liabilities exceed your assets? And generally, when you're making this assessment, you shouldn't be taking into account restricted funds or permanent endowment, i.e. those funds which aren't actually available to satisfy the claims of creditors. So then if you're solvent, happy days, you've got more options available to you. You can look, and maybe you have some time to try and find a merger partner to move forward with, or you can close down in a measured, careful and good way. Or as Luke was mentioning just now, you might decide to sort of move to a skeleton staff until maybe the administration changes, or it becomes clearer what the future in your particular sector might be. But if you're insolvent or likely to be insolvent, potentially insolvent, then your duties flip. And whilst you still have a duty to promote the charitable purposes of your charity, you've then got a new duty to have regard to the creditor's interests. And if you're insolvent, then broadly there are two processes that will be available to you. Administration, which is a type of insolvency process where an insolvency practitioner will be appointed with a restructuring plan in mind, and will try to turn the organisation around and then hopefully bring it back out of administration in a sort of form of rebirth. Or insolvent liquidation, where it's just not possible to save the organisation, and the insolvency practitioner in those circumstances will be trying to realise as much as possible for the creditors. It's also important, and it's the reason it's at the bottom of this first slide here, is to remember that you do have a duty, or your board of trustees will have duty to report serious incidents to the Charity Commission. And it's always difficult to know quite what the right moment is to report a serious incident, like sort of potentially insolvent situation, to the Commission. Our experience, and probably Luke's is the same, is that provided you've acted reasonably and you're taking proper professional advice and approaching things in a measured way, even if you're facing financial difficulty and need to report that as a serious incident, the Charity Commission will, signpost you to guidance, but broadly leave you alone to get on with implementing your plans. Next slide, please, Sheena. Just wanted to emphasise why it's so important to ensure that you know on a sort of weekly basis whether or not you are solvent or insolvent. And that's because if you're insolvent, then it may be the situation that your charity trustees find themselves having taken action which expose them to personal liability. I'm not going to go through each of these in detail. I put them on the slide, not really to scare anyone, and I hope I'm not doing that, but just to say that this is a very complex area of the law. There are any number of claims which may flow from an insolvency, and it is important in this circumstance that you take the best advice that you can. So on to the next slide. So this is the situation where you are solvent, and you decide that you want to wind up. So you need to start by referring to your charity's governing document to check what it says about dissolution or winding up, and generally there will be a dissolution or winding up clause. You then need to decide what will happen to your staff. Perhaps you're transferring certain of your activities to other organisations and the staff are going with, and there'll be some form of TUPE process. Or perhaps you'll need to be making them redundant, and you need to take advice on what the costs of that may be, because some organisations will call and get in touch and say that they think they can go through a solvent wind down process, only to find that they haven't taken into account redundancy costs. And once those are brought into the mix, there isn't quite enough money to get them to wind down in a solvent way. You also need to have a plan for your beneficiaries, both for, there's something gone wrong with the third bullet point, but don't worry about it. For the continuity of provision of services for your beneficiaries, how are you going to continue to provide for them, or will others be able to sort of step into the mix? And also a communication plan to decide at what stage you're going to start to talk to your beneficiaries about the closure of the organisation. And in part, that will depend upon the types of services that you're providing and the importance of the ongoing relationships that you have with those beneficiaries. So once you've looked at people, so the staffing and beneficiaries, you then need to turn your mind very much to settling your finances, because you can only close down solvently provided you've been able to meet all of your debts and liabilities. So to do that, you need to make sure that there are no unexpected liabilities that are going to pop up. As I mentioned just before, you need to check your grant and funding agreements to make sure that there's no clawback provisions that say on winding up or close down, we reserve the right to be able to demand full repayment. You need to understand what's going to happen with your land and buildings. So presumably you're going to sell land and buildings in order to realise cash which can be passed out on wind down, or perhaps you're going to transfer the land and buildings to other charities with similar purposes for their use. Need to have a look and establish whether or not you've got permanent endowment or any other special trusts or restricted funds that will need to be dealt with separately. And it may be in those cases that you're applying to the Charity Commission for permission to spend out those funds, or for permission to spend those funds, or to transfer those funds rather, to other organisations who can continue with the purposes of those particular endowments. By that point, you'll have worked out what your surplus assets are likely to be, and you'll then need to decide on the process. So there are two broad processes for winding up solvently. The first is a member's voluntary liquidation, for which you'd need an insolvency practitioner who would be appointed and would deal with the sort of final notices to potential creditors, etc., and go through the process, the insolvency process of a formal members of voluntary liquidation, which would need to then be voted on by the members of the charity. It is quite a formal process. Luke might have seen it done quicker. They tend to take at least 18 months to 2 years, even when they're being done reasonably quickly, to work their way through before the charity is finally wound up. And at least tend to cost around about £10,000 sterling, although it may be possible to find somebody who can help do it more cheaply. But the advantage of a member's voluntary liquidation is having been through the process of notification of creditors and making sure that there are no additional liabilities. Generally then, no claims can then be brought against the charity. The second process that is usually the one that charities follow is strike off, which means that you can leave the charity dormant for 3 months so that it's not undertaking any activities. And then after that time can file a short form with Companies House, file a strike-off fee, which I think is about £44. You send that into Companies House. Companies House put a notice in something called the Gazette, and provided no creditors come forward, you also need to send the notice to all your creditors, staff, and members. Provided nobody comes forward to object, then 2 months later the company is struck off. The disadvantage with the strike-off process, although for most charities it will do, is that if a creditor later comes along and wishes to bring a claim, the charity can be restored to the register at Companies House, or if it's a CIO, it can be restored as a CIO if that sort of strike-off process has been followed. You'll also need to put into your timetable the holding of relevant meetings of the trustees and members to pass the relevant resolutions. You'll need to decide as a board of trustees where any surplus assets should go, and where any legacy assets should be transferred. So it may be that there's an obvious home for some of the intellectual property or research reports or other sort of significant assets that have been created that will be of value to the wider civil society. And you will, in the months before you finally strike off, or want to find suitable homes for those assets to ensure that they can continue to be used to help civil society. But then when you're ready, so when you've dealt with all of the liabilities and you've found a new home for your assets, you then can apply to the Charity Commission to remove the charity from the register. But you will need to ensure that records are kept for 6 years. And that's the solvent winding up process. Next slide, I think, and we're nearly there. Luke, it's the last slide, I think.
I think that discussion about solvent winding up and the timings involved and the need for meetings and how long members' voluntary liquidation can take, all of that, I think, tells us that time is really valuable and you want as much of it as possible. And so if we can go to the next slide, getting on the front foot is really critical in these situations. You want to be ahead of the context that you're in as far as possible. You want to have done your research, whether that's in-house or with professional support. You want to have discussed your options and analysed them. And ideally, you want to have conversations with potential partners early, at the highest level on a confidential basis with your chair or CEO. You want that sort of level of buy-in. And if those conversations are taking place, they should be focused ultimately on the charitable purposes and what's in the best interest of the purposes and the beneficiaries. That should be guiding the thinking rather than identity, heritage, egos, roles, positions, all of which obviously can have a significant influence on the way people think and the dynamics in these sorts of contexts. But the framing question is, what is in the best interests of your charitable purposes? And the final thought is that the further, let's say, a project group can get with its thinking around the terms and what the future looks like in terms of strategy, business plan, integration, the better the instructions will be to your lawyers, and hopefully the better a job your lawyers will do. And the greater the chance I think you'll have of success, the further you can get with your own independent thinking about what the future ideally looks like. So I'll pass over to Blair at this point, who I think is going to moderate us through some Q&A.
Thanks so much, Luke and Jo. That was incredibly comprehensive and helpful. You really covered a ton of ground there. And what occurs to me is obviously how all of this stacks together. It's not just the kind of formal legal piece, it's the cultural piece, it's the governance piece. It's so much of this that we need to kind of align in ways that allow for the legal changes that might be necessary to flow. And I imagine everyone on the call has lots of thoughts about these things. If you do, please feel free to put a question in the Q&A box, and we can take them from there. One question, maybe to start with, Luke, coming back to you, but also for you, Jo, which is, I suppose, the flip side of those final tips, Luke, is what are the pitfalls that you tend to see most often when charities merge or wind down, and what kind of mistakes can they avoid that you see a bit more frequently, perhaps? Do you want to take that one, and we'll see if others come in the meantime?
Jo, do you want to go first, or shall I?
Yeah, no, I mean, I would say that in an emergency merger situation, which probably is what we're talking about here, you find that lay boards of trustees are very risk averse. And that means that sometimes, although the management and the SLT want to do it, can see the value, the trustees are much more reluctant, and they don't like to be pushed quickly. So it's it can be quite difficult to find the right board who are prepared to move quickly and seize the opportunity to sort of try and salvage something from a difficult situation. So I think at the moment it's the sort of risk-averse nature of volunteer trustee boards who kind of see liabilities looming large.
And I guess allied to that, capacity is needed to think about these things properly, to sequence conversations well, to make sure that you're engaging with the right issues in the right way. And it's easy to underestimate how much capacity that requires and at what level. And so you might have a board that is ambitious for merger, but underestimates how much work it involves and what it requires of the staff team. So it can work in both directions. And I guess keeping things going whilst at the same time negotiating a merger is an incredibly challenging exercise. And people who have been through it, talk about it as if it's a life-defining experience. So it's worth bearing that in mind, and lots of generosity and space will be needed, and kindness to others and to oneself going through this sort of experience.
Yeah, one of the other issues I think at the moment is that it's just not clear what the future is going to be. So there's a decent chance that a merger may happen, but it might not happen. It could fall over. So quite a number of our clients at the moment are having to run two processes in tandem. They're having to plan for potential insolvency at the same time as looking to merge, and running two quite complex processes at the same time can also be very challenging.
Absolutely, and through our facility that we mentioned, we're finding a lot of the value is coming from the sense making and the accompaniment and the thinking through of all of this in a kind of general way, as much as the specifics and technical and legal support that might be needed. It's working out what we do, and then, as you suggested, thinking then about kind of timelines and finances and everything else that then aligns with that. Another question is around timeframes. As we discussed right at the beginning, timeframes for this kind of thing are more condensed now than perhaps they were a few years ago. But as you also explained, there are certain procedures that just take time. Do you have any advice on sort of how to speed things up or expedite any of this from a legal or other perspective at this particular moment in time?
Shall I go first on this one?
Mm.
So something we do see where time is really of the essence is this parent subsidiary route as one way of approaching things, where there just isn't the time to really fully understand what the operations look like, what the liabilities might be in a sort of target entity, I suppose. That can create time, that can allow time to reflect upon whether a fuller integration is desirable. It's not an answer, but it's an option worth looking at. I suspect a lot of it will come down to being really clear about some fundamental options, and probably a relatively high level view on risk, in order to make some of these things happen quickly. That's not a legal answer, but if time is really of the essence, you obviously can't do the same level of due diligence. You won't be able to finesse the agreements to the same degree. You may not be able to do the same level of consultation, and bigger judgments are needed about, is the transaction desirable or not, and what evidence is there pointing in either direction.
Yeah, I just think that in that sort of situation, both boards of trustees will need to have done enough such that, where there's a higher chance that it won't be successful, should the regulator ever turn around and say, well, great, not only did you not manage to preserve the value in the charity that you rescued, but you've also caused substantial damage to your own charity. Why? That there's a sort of decent paper trail, audit trail showing the rationale, showing why you moved at pace to try and rescue what you believed or considered at that time to be, an essential, critical, or valuable service for some other reason, which was fundamental to your own charity's purposes. In terms of Blair, I think it's a really good question. How do we speed things up, and how do we, make sure we get there in time? I would say that where those mergers that I've worked on that have worked really well, there's been a really good project manager in place who's done it before. And normally with the staff of an organisation, you're very lucky if you find somebody on the SLT who's done a merger previously. They're quite unusual things still for charities to do. And I think if you can bring in the expertise to sort of sit alongside the SLT to sort of help guide the process and drive the project management side of things, then that will be really very helpful, I'd have thought.
If I can just add to that as well, when I've seen it go wrong, it's been when lawyers have spent lots of time negotiating things that are really not very important, and
Blame the
maybe
lawyers.
there have been sort of battles over the form of the agreement that are not particularly important in the grand scheme of things. And so getting really clear on what instructions are being given to the lawyers, and being careful about your choice of lawyers, and making sure that their instructions are boundaried and you're in control of the engagement, I think is really, really important.
Yeah, thank you both. I think those are all really key points, and it comes back again to how much of this is actually not legal. The pieces that you deal with are so important, but unless you've agreed on the values and the governance and the way forward, then it doesn't matter how well agreed the legal pieces are. It's not going to get too
Sure, I
far.
mean, the merger can't happen without the legal piece, but that's not the reason the merger will be successful. The
Absolutely.
merger will be successful because of everything else, not because of us. I mean, however great we are, Luke.
Yes, and to your earlier point, Jo, for everyone on the call, of course, we're not pushing mergers as a solution in themselves. We're not suggesting that anyone should wind down if this isn't the right fit for your organization. It's just that if you are considering this, of course, there are things to think about. But to your point, Jo, about sort of most people not having been involved in this kind of thing previously, that I think is a really important one. And there's so much of what you both said that has some degree of kind of impact on. So, for example, the idea of insolvency practitioners, there's a question about, where do we find those? How much do they cost?
Yep.
I imagine people haven't been involved with those kinds of people previously necessarily. So maybe do you have thoughts on that, or are there
Yeah,
other
no, I
networks
mean,
or resources?
anybody's can drop either Luke or I an email. I'm sure we work regularly with insolvency practitioners who have a kind of charity specialty. It is quite important to find insolvency practitioners who are familiar with charities, because there's sort of certain quirks that you need them to understand if they're going to be able to move at speed. But we work regularly with 4 or 5 different firms and the expertise is definitely out there.
Brilliant. Yeah, Luke, do you have additional thoughts there?
Similarly to Jo, there are certain names, certain individuals, certain firms that come to mind. We have relationships with people that we've worked well with in the past that we trust, that we know really do know what they're talking about. There aren't many in the insolvency world that really understand charities, that have deep knowledge. So we're probably working with the same people, I suspect.
Yeah. And also you need people who are able to go into a boardroom and leave the board feeling supported and educated, informed and reassured, rather than, running for the door and trying to sort of hand in their resignation first before, they can no longer do so. I mean, it's, insolvency practitioners are generally, well, they're a certain breed. And so the ones that work with charities have a better bedside manner, I would say.
Great, thank you. If there are other questions, please feel free to send them through. There is one other one about the thresholds in terms of size of organizations, and whether regulations differ by size, or ways organizations are operating. What you talked about, I think, was broadly general in terms of the charitable sector, but is there anything to think about there if you're a particularly small or a particularly large entity beyond what you both touched on generally?
I guess the only thing I would say on that, I don't think there are any particular regulations that are relevant. There might be implications for the receiving charity in terms of whether it crosses audit threshold or something like this, but let's say proportionality might look different depending on the context. And that goes for due diligence. It goes for the level of engagement with provisions in a transfer agreement, for instance. So with very, very small mergers, you might be looking for very minimalist legal support, potentially. And there are similarly situations where assets have been transferred in what you might describe as divestment contexts, where everybody's taken the view that given the nature and size of the assets, there's not going to be any formal due diligence or representations, and the assets will just be transferred in a very simple asset transfer agreement. So in some situations, that can be appropriate if you can get comfortable with the nature of what's transferring and the fact that there's very unlikely to be any risk involved. I don't know if that's relevant to the question, but it's just worth bearing in mind. There are, I guess, slightly different ways you can go about structuring an engagement and structuring a merger depending on size.
Thanks, Luke. Jo, anything to add there?
No, I don't think so. I mean, I'm not aware, as Luke said, there's a principle of proportionality, but if you're a smaller charity, you still have to make sure that you're acting in the best interests of your organization in deciding to agree to the merger. So you will have needed to have undertaken due diligence on your merger partner, etc. You don't get a free pass on that just because you're smaller. And unfortunately, it's the case we often see. Smaller organizations tend to have kind of bigger and thornier problems that need more legal support and can't afford it. So the size of the problems that you encounter are not necessarily related to the size of the organizations either.
Absolutely. I know we're quickly running out of time. This has been a really, really interesting conversation. Do the two of you have any final tips or hints for how to make mergers or wind downs or any other kind of legal transitions that organizations might face at this point more effective? Maybe 30 seconds each. Luke, to you.
I guess I would just go back to, do your best to be ahead of the curve, ahead of the circumstances. Don't wait until you have to think about it. Try and get stakeholders internally engaged with what the options are. Do some in-house research. Think about what your contingency plans are, and try and start conversations early if you're going to have them from a position of strength when you've got some resources, you've got time, if possible.
Yeah, I would agree with that. And I would also say that sort of use lawyers sensibly. So because we do this often and regularly, you know, an hour of Luke or mine's time early on in the process can be really helpful, just in helping to ensure that the structure is framed in the right way and that you're moving forward in the right direction. You then might not need to talk to us again for 2.5 months while you go off and do your due diligence or something, but that early conversation can just make sure that the thing's pointing in the right direction.
Brilliant. So yes, prepare ahead of time from a position of strength, engaging incredible legal support such as yours at that stage is really key. I know Sarah can maybe mention this, and I'll hand over to you, Sarah, in a second, that ISLP more broadly is available to answer questions and support if organisations are thinking about these sorts of things. As we mentioned at the outset, we also have a facility through which we were helping to organise this webinar called Civic Strength Partners. We can share links and we'll do so afterwards with everyone. You can submit information if you're thinking about these kinds of issues, and then we can support you both in terms of accompaniment and then the financial resources to pay for technical expertise, including potentially lawyers to help you carry out these transitions. So that is a facility that's open, and we would love to help anyone here that's thinking about this. Thank you, everyone. This has been really, really interesting. Sarah, over to you. Any final words or thoughts on all of this from your perspective?
Thank you. Thank you, Blair. Thank you, Jo and Luke, we're so lucky to have such notable experts in this area to be advising all of us. So thank you very much for your time. Thank you, Joaquini. Thank you, and Sherry, and all those at Accountability Lab, Development Gateway, and Digital Public that made this possible. Glory Quinoa from ISLP, thank you. I will say that for legal requests, we will drop in the Q&A, and you will also be receiving the materials and some resources that Luke and Jo were generous enough to share with us. We will share those with you by email after this webinar, so look for that in the coming days. And you will also have an email to contact ISLP for legal, specifically legal questions. And if you have other questions that you include in those, we can share those with Accountability Lab and Development Gateway, of course. But legal questions will be treated confidentially and privileged, of course. So if you are looking for individualized pro bono legal support, we can help to set you up with that, or in partnership with our partners, see if we can tee up funding to help facilitate that. There you go. It's now, Sheena, thank you for including Glory Quinoa's ISLP email address for legal questions. Thank you all for being with us today as we navigate these very tricky but very important questions.
Thank you, Sarah. And finally, I think I'm correct in saying that this recording won't be made public, but I think it could be shared with participants here if you want to pick up on this again, or have forgotten anything that's been said. You can get access to this later as well. We'll send around the link. Thank you, everyone. This was fantastic. Thank you, Jo and Luke in particular, for all of your expertise and your time. We know how valuable it is and how busy you are. Let's all be in touch. Thanks again, and we'll continue this work together at some point very soon.
Thank you.
Thanks, Luke.
Thank you very much.
Thanks, everyone.